Here is what they are not showing you. Not on cable news, not in the rushed headlines, not in the carefully worded legal summaries. What triggered the most explosive federal courtroom shutdown of early January 2026 was not shouting, not contempt citations, and not a theatrical meltdown. It was silence. A silence so sudden, so deliberate, that it froze an entire courtroom mid-breath. Judge Marcus Caldwell did not raise his voice. He did not strike the gavel. He did something far more unsettling. He stopped everything, and in that stillness, he ordered United States Marshals to move. In a packed federal courtroom, in front of a seated jury, national media cameras, and a defense team that seconds earlier believed they were in complete control, Judge Caldwell issued an order that instantly altered the trajectory of the trial. The defense laptop was to be seized immediately. All electronic devices at the defense table were to be surrendered. No debate, no delay, no warning. What followed was not merely a procedural disruption. It was a systemic rupture that sent shockwaves through the legal community nationwide. The question that now dominates Washington, legal circles, and political media is simple but dangerous. What exactly did Judge Caldwell hear that made him shut down a multi-million-dollar fraud trial on the spot? What was captured? Who was speaking? And why, since that moment, has nearly everyone involved gone silent? This was not an ordinary case. It was a high-profile federal fraud prosecution involving enormous financial stakes, politically connected figures, and witnesses whose testimony threatened to dismantle powerful interests. Careers were on the line. Reputations were already bleeding. Judge Caldwell had been presiding over the case for months, navigating a defense team that appeared unusually prepared, unusually confident, and uncannily prescient in anticipating the prosecution's moves. Observers noticed. Prosecutors noticed. The judge noticed. But suspicion is not evidence. Until it was. During a routine recess in early January 2026, the jury exited the courtroom. Lawyers clustered at their respective tables. Conversations lowered. Assumptions hardened. Everyone believed the microphones were off. They were wrong. A courtroom audio system, installed for accessibility and official record-keeping, remained live at the defense table. Whether by malfunction or design remains under investigation. What matters is what it captured. A private conversation unfolded. The lead defense attorney confirmed that a key witness had altered her testimony. He stated that a new version was ready and that the prosecution had no idea contact had occurred. Another voice responded. A voice not belonging to any known defense team member. That voice reassured him. The witness was frightened. She would say what she had been instructed to say. The only priority was ensuring the judge never discovered the contact. Then came the phrase that changed everything. A sentence so chilling that court staff monitoring the audio immediately escalated it. Judge Caldwell would not know until it was too late. Within moments, the recording was delivered to the judge. He listened. Once, he stood, and he returned to the courtroom. Witnesses later described his expression as unnervingly neutral. No visible anger, no surprise, just precision. He addressed no one except the defense table. He ordered the lead attorney to remain seated. When the attorney attempted to rise, the judge repeated the command. That was the signal. The marshals moved, not toward the attorney, but toward the open laptop. The courtroom erupted. Objections were shouted. The jury was removed. Prosecutors sat frozen, unaware of the full scope of what was unfolding. Devices were bagged, phones, tablets, external drives. Careers vanished in seconds. The judge then escalated further. The trial was suspended indefinitely. Defense counsel were barred from contacting the defendant, witnesses, or each other. Jurisdictional restrictions were imposed. And then came the sentence that drained the color from every defense attorney's face. At that moment, a federal judge had publicly accused defense attorneys of potentially criminal conduct based on evidence captured inside his own courtroom. The legal equivalent of a nuclear detonation. Pause for a moment and ask yourself this. If you were watching this unfold live, would you see a judge defending the integrity of the court, or would you see a man crossing a line that judges are never supposed to cross? Because the country is now split. Defense advocacy groups reacted within hours, accusing Judge Caldwell of judicial overreach and constitutional violations. They argue the seizure of attorney materials without a warrant shatters attorney-client privilege and sets a terrifying precedent. Civil liberties attorneys warn that if judges can act on overheard conversations, the Fourth Amendment becomes conditional. Social media exploded. Some hailed Caldwell as a hero. Others labeled him a tyrant. Legal commentators clashed openly on national television. Was the recording legal? Was the microphone supposed to be active? Was the evidence admissible? Did the judge have emergency authority under the crime-fraud exception? Or did he allow weeks of suspicion to override procedural restraint? But here is what complicates everything. This did not begin in that moment. Weeks earlier, a key witness, Maria Delgado, had begun to unravel. Once a devastating prosecution witness, her testimony suddenly softened, numbers blurred, documents became uncertain. Her attorney quietly submitted revisions. Prosecutors raised alarms. They could not prove misconduct, but they sensed manipulation. The judge acknowledged the concern, but stated correctly that suspicion alone was insufficient to act. His hands were tied. That recording did not simply add a new piece of information to the file. It changed the rules of the game. In a single stroke, it turned what had been instinct, suspicion, and courtroom intuition into something far more powerful and far more dangerous, evidence that could be preserved, reviewed, litigated, and weaponized. Judges almost never receive a clear, recorded window into what is allegedly happening behind the scenes while a trial is still unfolding. They hear arguments, they evaluate credibility, they issue rulings based on what is presented to them in open court. But a recording like this is different. It is not a lawyer's framing or a prosecutor's theory. It is a captured moment, a raw glimpse behind the curtain. And once it exists, it cannot be unseen. So ask yourself a harder question, the kind of question that forces you to confront how power actually operates in the justice system. If you were Judge Caldwell and you heard what he heard, would you hesitate? Would you pause, call a closed hearing, and risk giving the defense team time to coordinate, delete, or reframe? Would you wait for a warrant and accept the possibility that crucial evidence could vanish in the meantime? Or would you do exactly what he did, move fast, move publicly, and take control before the situation could be contained or spun? Because here is the detail most people missed while they were distracted by the spectacle of marshals stepping toward a defense table. The seizure looked dramatic, but the drama was not the main event. The machinery behind it was. While the courtroom locked onto the visible confrontation, the real work was already underway. During that recess, before the public realized anything was wrong, Judge Caldwell had already initiated contact with federal prosecutors. He did not rely on vague discomfort or courtroom gossip. He moved to preserve chain of custody, ensuring the audio was secured, documented, and protected against claims of tampering or contamination. He began assembling the legal justification that would allow immediate action under the crime-fraud exception, the doctrine that strips attorney-client privilege when communications are used to further ongoing criminal conduct. And while everyone else assumed they were still in a routine break, investigators were already being mobilized, not as a theoretical next step, but as a response already in motion. This is the point that separates panic from purpose. From the outside, it can look like chaos, like a judge snapping, like a courtroom losing control. But the internal sequence suggests something else entirely. It suggests execution, not improvisation. A coordinated, rapid response decision made by someone who believed he had finally obtained the proof necessary to act, and who understood that delay is often where evidence dies. The public saw a laptop being bagged. What they did not see was the timeline behind it, the calls being made, the documentation being prepared, and the legal scaffolding being built in real time to justify extraordinary steps before anyone could obstruct them. That is why legal analysts are now whispering what they will not always say on camera. Caldwell did not gamble emotionally. He calculated. He watched this case for weeks, possibly longer, absorbing patterns that raised concerns but did not yet rise to admissible proof. He waited because judges are trained to wait, and when the proof finally landed, he struck in a way that was public, decisive, and difficult to unwind. The public nature of it mattered. A private seizure can be disputed quietly. A public seizure in front of witnesses, lawyers, and a court record makes it harder to rewrite history later. It forces every party to react on the record. It also signals to anyone involved that the window for concealment has closed. But that kind of action carries consequences, and those consequences do not stay contained within one courtroom. The ripple effects are already spreading through the legal system. Defense attorneys nationwide are now re-evaluating how they communicate, where they communicate, and what assumptions they make during recesses, sidebar moments, and off-the-record exchanges. Some are treating this as a warning shot, proof that complacency in modern courtrooms is a liability. Others see it as a chilling escalation, a moment that threatens to blur the line between monitoring for security and surveilling legal strategy. Federal courthouses are auditing audio systems, reviewing policies on microphone zones, recess procedures, and access controls because no administrator wants to be the next building where a technical glitch becomes the spark for a national firestorm. Across the country, motions are already being drafted, not just in this case, but in unrelated cases where defense teams now feel compelled to challenge recording protocols, chain of custody practices, and the scope of what judges can authorize without warrants. And appeals are not merely likely, they are inevitable. Every step that follows from those seized devices will be contested. Every derivative discovery will be litigated. Every ruling will be scrutinized for precedent value, because this case is no longer just about one defendant and one alleged act of misconduct. It has become a test of boundaries. How far a judge can go in the name of protecting a trial, how quickly privilege can collapse under the crime-fraud exception, and what happens when courtroom technology captures something that was never meant to be heard. However it ends, the echo will last for years because courts do not just decide cases. They establish rules, and this recording, more than anything else, threatens to rewrite them. Instead of retreating into silence and letting the legal process speak for itself, lead defense counsel stepped directly into the public arena and made the situation infinitely more volatile. In the days immediately following the seizure, he held an impromptu press conference on the courthouse steps in full view of cameras, reporters, and a rapidly gathering crowd, and he framed the judge's actions not as a contested procedural decision, but as outright tyranny. He accused Judge Caldwell of abusing power, violating constitutional rights, and acting like an unchecked authority figure rather than a neutral referee, and he promised a scorched earth response, publicly vowing to take the fight all the way to the Supreme Court, if necessary. Analysts, including former prosecutors and veteran defense attorneys, warned almost instantly that this was not bold advocacy. It was a catastrophic strategic error because when an attorney is under scrutiny for alleged obstruction and witness tampering, going public with inflammatory attacks can be interpreted as escalation rather than defense. And escalation is exactly what courts treat as a risk factor, not a virtue. Within days, the temperature outside the courthouse began to rise. Protesters appeared, first in small clusters, then in larger groups with signs, chants, and accusations of judicial corruption, turning the building into a flashpoint rather than a venue for adjudication. Online rhetoric accelerated even faster, with partisan pages, anonymous accounts, and opportunistic influencers pushing the narrative into darker territory, turning legal debate into personal warfare. Then, the line was crossed. The judge's family became a target. Personal information circulated. Harassment followed. Threats surfaced. some vague, and some pointed enough to trigger immediate law enforcement response. The U.S. Marshals Service assigned protection, increased security protocols, and relocated the judge's family to an undisclosed location, a rare and severe step that signals officials believed the risk was credible, not theoretical. Inside the courthouse, security tightened to the point that the courtroom itself effectively transformed into a fortress with heightened screening, restricted access, and an atmosphere that communicated one thing clearly: this was no longer merely a legal dispute. It had become a public pressure campaign with real-world consequences. Ask yourself this: when a judicial action is followed by intimidation, threats, and public targeting, who is actually undermining the system? The judge enforcing boundaries, or the people trying to punish enforcement? And as that pressure escalated, the unanswered questions began stacking up, multiplying, and refusing to go away. Why was that microphone still active during recess when the system is supposed to go dormant? Was it a technical failure, a configuration error, or something far more deliberate? Why has no one identified the second voice captured on the recording? A voice that did not clearly belong to the legal team, yet appeared to speak with confidence about controlling testimony and preventing discovery. Why did the key witness's testimony begin shifting at the exact same time the defense team's behavior intensified, becoming sharper, more anticipatory, and more aggressively calibrated against the prosecution's strategy? And why is the FBI's Public Corruption Unit now involved in what should, on paper, resemble a conventional witness tampering inquiry, an escalation that signals investigators may be looking at something broader than a single incident in a single courtroom? Sources suggest that forensic review of the seized devices has revealed irregularities that extend far beyond the initial allegation, including patterns that are difficult to explain as routine legal preparation. The full recording is reportedly longer than what has been publicly referenced, and parts of it remain sealed under motions that cite national investigations, language that carries weight because it implies sensitivity, scope, and potential connections outside the immediate trial. National, not local, not state, not isolated. Meanwhile, the formal case posture remains frozen in place. The trial is suspended. Bail has been revoked or held in limbo pending investigation. Defense attorneys have been suspended or placed under professional review. A law firm has effectively vanished overnight, going dark in a way that fuels speculation and signals internal crisis. The seized devices sit in federal custody, subject to forensic examination under tightened chain of custody procedures, and no public timeline has been offered that would reassure anyone that the process will resolve quickly. Through all of this, Judge Caldwell remains silent, protected, and unmoving, a posture that can be read as discipline and control, or as the posture of someone operating under constraints the public does not fully understand. So here is the question that matters, the one you cannot avoid. Is this the story of a judge who caught misconduct in real time and paid the price for acting decisively? Or is it the opening act of something far larger, far messier, and far more dangerous than anyone anticipated? A conflict where the courtroom was merely the stage and the real fight sits behind the curtain. Because stories like this do not end cleanly, and the moment the public thinks the ending is obvious, that is usually when the ground shifts again. And before you scroll away, I want your opinion. Do you believe Judge Caldwell was right to act immediately? Or did he cross a line that should never be crossed? And if this can happen here, what does it mean for the future of every courtroom in America? Drop your thoughts below and stay with this story, because the next development will not be small.